Jordan Scott here at the Secretary of State's office, reporting on ballot initiative number 175. Ballot initiative number 175 is an attempt to ban gender affirming care for minors in Colorado. What we're seeing today is widespread medical malpractice, especially when it comes to minors. You see, these treatments that they put these kids on aren't even FDA approved. Not only aren't they FDA approved, but they sterilize a child. So this is widespread medical malpractice and medical experimentation on children. And this ballot initiative would stop all that. So we're going to continue to cover this ballot initiative. We're going to continue to keep the public informed on what they can do to support it. And we're going to engage in the process. I'm here with Keegan today, and he wanted to say a little something about his feelings on gender affirming care for minors.
So this abuse for children has gone on for far too long. It's known that we are born and came into this world. God created us with either a penis and balls or a vagina. You were either born a man or you were born a woman. There is no transgender. There's no LGBTQ. I believe that's a way for them to gain power and to try to hold themselves above others. There's a lot of manipulation going on within the Capitol, a lot of corruption going on, and you can see it living proof just in the Capitol itself. Thank you for your time. My name is Keegan Stone.
Thank you, Keegan. Appreciate your time. Have a good God bless.
All right, now we're going to jump to 191. I'm just joking.
Oh, I was like,
Initiative number 2023-24, number 175, informally captioned, prohibit certain medical procedures for minors. Darcy and Wade is. And then are you Darcy?
he's way down there.
Darcy, right. Just want to make sure you guys. Let the record reflect that both of the designated representatives are present in the room. So I'm just waiting for someone to shut that off because we have microphones. I realize you're struggling. That's okay. That's okay. Don't worry. We'll do our best here. Mics will pick things up. That's all. So thank you. Okay. So let the record reflect that both of the designated representatives for 175 are present in the room. If they would like to introduce themselves and let us know what the single subject is of 175.
My name is Dr. Wade Goodall. I live in Colorado Springs.
My name is Darcy Sheening. I live in Monument, Colorado. The single subject is prohibiting the medical transitioning of minors.
Okay. So, similar to the discussion we had on the prior measure, or 2 measures ago, I think 149. This measure is the breadth of liability on this measure is extensive. I'm not sure if it warrants a second subject or if it is something that goes to clear title. I mean, I think with the extending liability to until the minor is 48 years old, even if there's consent, may just really go towards the fact that it's a ban as opposed to single subject. Are there any concerns from the other members of the board regarding single subject and 175?
Chair, question about 2 things that not sure we're raising you. Is that better suited for single subject?
No, I think that's a jurisdictional issue, so we should talk about that now.
Subsection of the measure. Section 8B. Language is added, notwithstanding whether a minor or a parent of a minor brings a civil action pursuant to subsection 7 of this section. believe that was in response to the question. So question 7 was raised. Is the Attorney General required to bring an act in the case to minor alternative is not? Looks like you also added that the Attorney General has a 20-year statute of limitation to bring an action to enforce that violation.
Yeah.
Did that come up in review and comment?
It came up in comment whether or not the Attorney General was responsible for pursuing if there was no victim that stepped forward. And we wanted to make it clear that the Attorney General still does have that responsibility, but also set a time limit.
Time limit isn't a statute of limitations, so the clock in which he's mandated to bring this action.
Well, it's both in practice, because if he doesn't bring it within that amount of time, then can't bring it. Or should say here.
Second question, subsection 8. Professional conduct. It's like a division of professions and occupation, disciplinary action for any person performed, prescribes, provides, administers, or attempts to medical procedure. I saw that.
You didn't see that in the original question.
Correct. I didn't see that raised by legislative council staff.
It was raised in their initial set of questions. The council staff, there you go. It's where they ask the question about what is the DA's responsibility, or is there if there's no victim, then how does this become pursued? So that was added to partially satisfy that question. We wanted to widen it and make sure there were a lot of questions about what is the penalty, or what if there's no victim. So we added these to make it very clear that if a healthcare professional is performing these treatments, then they are subject to the penalty that's listed here.
Ms. Orson, just a reminder, you're looking at 8B, that last sentence? Or 9B, thank you, I'm sorry.
Yeah,
So I raised 8B and 9B.
So when LCF asked us what is the penalty, we feel that making the penalty more specific in this initiative still satisfies the single subject, because there has to be a penalty when a crime is committed. So if I wanted to write a new law for, you can't steal bread, I wouldn't write 2 separate initiatives. If stealing bread is now illegal, here's the penalty. So that's why we included these in this draft.
I'm not raising for the purpose of single subject.
Oh, okay.
So much as I'm sure you might speak this better than I. State law says that any amendments made between review and comment and title board has to be in direct reaction or response to the questions laid out by the legislative council staff, and whether or not the changes you made here.
Oh, okay.
We're straying outside the 4 corners
Okay.
of that review.
Sure.
And so that is in 140, 105, or 106. And so, because the idea is that you want to provide the public notice of what this does, and if
Right.
it's something where we've seen some grammatical errors, and so I think that's a question for the board, because it needs to come before a single subject, because it relates to whether the board has jurisdiction to set title. And so so it's 105, 140, 105, 1, and it's a very long section. Um, sorry, it's two. After review and comment meeting, but before the submission, the Secretary of State for title setting proponents may amend the petition in response to some or all of the comments of the directors of the Legislative Council and the Office of Legislative Legal Services or their designees. If any substantial amendment is made to the petition, of an amendment in direct response to the comments of the directors of Legislative Council and the Office of Legislative Legal Services, the amended petition must be resubmitted to the directors for comment in accordance with subsection 1. So I think the question is whether the changes in 8B and 9B are responsive to the comments, and generally we include comments that are in the written comment and then things that are brought up in committee as well. And so I think for 8B, the question to me is whether or not adding a statute of limitation of 20 years sorry,
Yes. Not actually adding the 20 years.
I apologize. Sorry, notwithstanding whether a minor or a parent of a minor brings a
Yeah,
civil
that's what we
right.
got it.
Just one point, Madam Chair. I think that's directly responsive to
Mhm.
question
Yeah.
7.
Yes.
It's the phrase within 20 years. I was questioning, is that outside the question? Two phrases added to 8B in response to question 7. The first clause and then the within 20 years.
Right. So I'm sorry, Mr. Gray, were you saying that within 20 years was already there?
That's my reading.
Let me look at the original. 8, oh, the final, whoops. 8. The within 20 years was there.
Yeah.
And maybe the amended changes in another situation like this where so for 8B, if you look at your amended version, you highlighted it within 20 years, but that was already there. Or you didn't highlight it, you put it in red.
We put it in red. We changed some of the grammar. I think we took out a comma, added a comma at the end. So you're right. That should be in black.
Okay.
I'm not sure. I don't think we have an issue there.
Okay.
The 9 is probably.
It is important to provide the correct amended tricky, but for to make sure we are tracking. And then so under 9, so 9B is completed. And so, apologize. So you added why again did you add 9B?
That it was to more directly address the question in the LCS hearing, because the question was asked, so what if a healthcare professional does this treatment? And so we wanted to specifically delineate the healthcare professionals with 9B.
So, because I'm assuming in 9A, an alleged violator's appropriate regulatory authority. And so on that language, which was obviously not added, was already there. The liability here is on a healthcare provider, I think also the institution, but then also anyone who supports, correct?
What do you mean support? I apologize. Can you clarify?
Sure, I'll pull out your language and see.
You're referring to our language then, not
Yes.
your support. Okay, yeah.
So, because essentially what the point I'm trying to make is that for 9A, you're sort of saying the potential of violators, so an alleged violator's appropriate regulatory authority. And while the majority of the liability rests on the medical provider, it's not liability is not exclusively on a medical provider, correct?
Yes,
Because obviously it could be a parent
correct.
and it could be someone who supports.
Yes,
And that support could hypothetically be a neighbor who drives someone to a medical appointment.
correct.
And so a licensee, registrant, or certificant. So if your lawyer is a neighbor, are you reported to the bar? Or is this really just for doctors?
If your lawyer is a neighbor.
Like you're the neighbor that gives the minor and the parent a ride to the clinic.
Well, I suppose we could address that here, but when you talk about attorneys, I mean, that's handled by the Attorney Regulation Council, so I don't.
I'm just wondering who a licensee, registrant, or certificant engaged in unprofessional conduct or is subject to discipline pursuant to this title. Who is it we're talking about?
Well, it could be the physician, it could be the manager of a clinic, it could be anybody who's licensed or credentialed and is involved in this procedure.
So could it be a neighbor who is an attorney who drives the minor to the clinic?
No, because we very specifically spelled out unprofessional conduct.
And that professional conduct wouldn't relate to being an attorney, it would only relate to being a medical conduct.
Correct, yeah. Because otherwise, that's a slippery slope. If we talked about attorney, then who else are we going to start talking about? Are we going to talk about teachers? We're just specifically addressing the healthcare setting.
Yeah, I mean, I think the slippery slope argument isn't one that's well supported by this measure.
Yeah.
So I don't think that's something you should rest on, because if it includes a neighbor for liability and it includes liability for 30 years, that slope is as slippery as it can possibly get.
Okay.
And so this does not say doctor, that's all. I don't know
Okay.
what Title 12 is, but I'm just trying to ask why you added it. Because it says that they were like a registrant.
Would it be more appropriate to just strike 9?
I'm not sure. I just wanted to pause on that. I mean, I think to me, I read it as relating to it in terms of, oh, you're reporting them to the board, right? So not only do they have liability to the board, but you don't say anything about medical physician or the provider providing the care here.
Okay.
And again, it's a broad measure. So, but this, I think the question we're on right now is really whether B was responsive to discussion during the hearing. That's a question for you. So I don't think. But was B added in response to discussion during the hearing?
There was a lot of discussion in the hearing about, well, who's included in this? Is this for medical professionals? And so we were actually trying to limit it more than we were trying to expand it with this addition.
Okay.
Seems probably the opposite, but.
Do you have any other questions on that, Mr. Morrison, or does that resolve your concerns?
Went through the review and comment memo, and you only referenced to subsection 9, is question 9. The question specifically, what does emergency action mean? What the proponents consider the fine?
Did you say 9?
Subsection 9?
Right, but then question, what was it?
Question 8.
Oh, question 8.
Yeah, question 8.
Section, and then the question is, okay, 1230, 123.9 was. And it talks about emergency action. I did not listen to the review and comment on this one. Right. Do you have any thoughts on this, Mr. Berry? So I don't know whether or not it sounds like it was addressed during the discussion.
I honestly don't.
So in addition to this, it sounds like pending question on jurisdictional issues, whether there was a substantial, amendment in violation of statutes, or there are other discussions or concerns regarding the subject. I mean, they're separate, but just in terms of.
It's my answer. I suppose it's possible to come up early, review and comment, and the statute doesn't reflect whether a technical change can be made in reaction to a written person's comment. I recall this one was about 10 or 11 minutes. Yeah, the recollection I believe was brief. So I take a recess and listen to it. Proceed.
Question. I mean, I think to answer kind of your first statement there, we recently, in last one or two meetings, we did, I think if something is brought up during the hearing, I would be inclined to include that as something of being responsive and not limiting it just to the memo. It's true that section 2 on 14105 is not so prescriptive, but it may be worthwhile to listen to it. We believe that it's substantial.
If I could
Sorry,
add,
let me just.
go ahead.
I mean, I guess one thing is that 1A does already say that the alleged violator is appropriate regulatory authority. I don't know if it is drastically different than what they're doing in 9A.
Madam Chair, I think this may also actually be in response to question 2. What happens if health provider claims the medical procedure? Seems to a medical professional.
Yeah. It does seem reflective of that. Okay, I think we're inclined to find that it was responsive to the comment, but that there may be a time where we do need to take a recess. So with that, I'll entertain a motion on, and I'm sorry, I apologize, did you want to make a comment?
No, it's okay. I was just gonna add that it is a bit redundant. There were several questions asked about the penalty. As you said, Mr. Berry, is it? Question 2 had several different questions wrapped within it, and it was a quick hearing, so there were a lot of things addressed about the penalty pretty quickly. But we're open to. I almost feel like it's redundant anyway. So, might be.
So I think with that, I will entertain a motion on single subject.
I move that the title board finds that proposed initiative number 2023-2024, number 175, has a single subject and that the board has jurisdiction to set a title.
Second.
All those in favor?
Aye.
Aye, that motion passes. The board has jurisdiction to set title. Much like my statement in the prior measure, I'm inclined to try and make this more of a layperson term. I'm going to start suggesting some amendments. I realize these may not all stay. These might not be ones that everyone likes, but so I would say performing on 2, after performing, leave performing. Gender affirming surgery or medication. And then I would and then delete all the way to and in connection therewith. And then imposing after therewith on 4. Liability on the healthcare provider who performed the procedure. And any person who assisted until the minor is 48 years old. Or 10 years after their death. And then semicolon. A healthcare provider is liable even if the minor and parent consented to the procedure. Allowing a semicolon. Allowing any person to advise the state's attorney general of a prohibited procedure. And requiring the attorney general to file a claim for up to 20 years after the prohibited procedure occurred. So let's see, it would be to file, I think it would be a lawsuit instead of claims. So on 8, replace claim with lawsuit against, instead of lawsuit against the provider or anyone who assisted. Right where you are, yeah. Or, yep. And then it would be for up to, not for. I don't want to make sure that gender affirming surgery or medication isn't. What did the term they used?
Line 7, that should be advised, not advice. And it should be a prohibited, not prohibitive.
No. Very. I mean, I think we can say it's a ban, but I think we really need to show that there's pretty extensive liability in terms of duration. I think it's also the fact that you can't, even if you've consented, and the death of the minor is also very broad in terms of, so it seems like there could be liability if it says, this is 7C, the parent or next of kin of a minor may bring a wrongful death action against a healthcare provider alleged to have violated the section if the injured minor is deceased and the minor's death as a result of the physical or emotional harm inflicted upon the minor by the violation. So if the child had gender affirming surgery and then someone committed a hate crime and killed them, I think we could sue the doctor. That is what this measure. But to me, the duration of the consent, the duration of the statute of limitations and that consent is not I guess an affirmative defense or and then I think you could delete the rest of it. I don't know if there's anything in there that does the board have thoughts about what I have suggested. Do you want to?
We go up to the start. I think it needs to be performing gender affirming surgery or medication on a person under 18 years. We don't have minor any place in.
Oh, right. Thank you. And so does this define minor?
Minors defined in the definitions as one
18.
under the age of 18.
Okay. Thank you. That is a good
And I think it's just under 18 years. They do not need the.
Also the liability in terms of anyone who assisted. I was looking for this earlier. Sometimes people put footnotes on, page numbers on their motions. That is wonderful. I encourage all of you to adopt page numbers, especially if you file and mark people. So there are some any person not shall a person shall not. I think the medication is probably clear, right? Okay. A minor, the parent of a minor, injured as a result of a violation, may bring a cause of action against a healthcare provider, provider person or the entity alleged to violate this section, or healthcare provider person or entity that supported the alleged violation of the section. And again, this is really broad, and so this is a question for the proponents. 7A, and it says, or other entity that supported the alleged violation of the section. It doesn't say, I don't know if you're referring to medical staff, I don't know if you're referring to just the receptionist, I don't know if you're referring to the neighbor who
I get it.
drove you.
I understand. We're referring to medical staff. That could be anyone from the physician on down to the person who came in and took vitals. So the nurse, the LPN, whatever you want to call it. But no, attorneys, neighbors in this right here. No, I wouldn't say that applies to them.
When you say right here, you mean 7A?
Yeah.
But so if two parents and the child consented when the child's, 14, or 17, and then when the child's 45, the parents are now divorced, one of the parents could sue if they they could sue the doctor.
That's correct.
And then a minor the parent, and then, but not next of kin. The next of kin is only for the wrongful death.
Yes.
And then I guess I just don't know if this covers the death of the child. The result of physical or emotional harm inflicted upon the minor by the violation. Questions? Do you want to maybe just for a moment, Cheryl, do no track changes? I might read it, but if the board has any questions or thoughts.
think we talked about my places, maybe mine too.
Could you just say a minor?
A minor is defined later on.
I don't think, you want to say minor instead of person? Yeah. And she did say performing surgery or providing.
Providing.
Okay. Hold on, just,
Sorry.
that's okay. I know it's hard, but, it helps with dialogue, but, sorry, Merit. Before medication. Sorry, not there. Thank you, Cheryl. Oh, and healthcare is hyphenated in one place and not in the other. I think we don't need that. So concerning, or should we just say instead of just prohibiting, instead of concerning a prohibition on, just say prohibiting a healthcare provider from performing? And then take out on. And then at the between before performing on the first line. And then we have I suggested gender affirming surgery. The proponents also had said prohibiting the medical transition of minors. Thoughts on what
That might be better than this one.
keep gender affirming or yeah. Okay. Or providing the medical, well, yeah. It would be the medical transition. The only thing, the medical, I feel like puberty blockers are somewhat well known. For the medical, so would we need to say performing gender affirming surgery on or the medical transition of? I kind of like medication. I think I would either include them all or because I think medical transition still sounds surgical to me, where medication.
Medical.
Because I don't know if medication transitions as opposed to suppresses it's like a puberty blocker. So I'm not sure. What do you think, Mr. Morrison? Do you like the medical transition of or providing I think providing medication. I so what was it before Cheryl before the medical transition? maybe could you say performing, yeah, so maybe performing gender affirming surgery, comma, medical transition. Or providing medication. But too much, we need to put some of that on board, but
I may go back to performing gender affirming surgery or medication.
or providing, okay. So then we would say performing gender affirming surgery on or providing medication to.
Would we be able to change gender affirming surgery to gender transitioning surgery? It is not our belief that it is gender affirming. That's not a term that's based in science.
I think that's okay.
Okay, thank you so much.
Yeah. Transitioning. Yeah. And
And with that,
okay. And so for the board, I think it's, clear that 30 years after they're 18, so you're saying until they're 48, which is more clear. Are there any comments or questions from the board on the draft?
Madam Secretary,
Yes.
it's 20 years. So you said 30 just a moment ago.
Oh, and also too, I'm the secretary, but thank you for the vote of confidence.
so would it be until the minor's 38 years?
Yes, I think that's right. I'm sorry. I apologize. No, within 30 years from the date of the minor's 18 years of age. And so that, yeah,
Okay,
so that's 7.
thank you.
Thank you.
No.
And 20 years was the Attorney General.
Correct.
Any questions on my mind?
Madam Chair, I do not see any hands.
Okay. Vote Initiative 2023-24, number 175. The title as designated and fixed by the board is as follows. A change to the Colorado Revised Statutes prohibiting a healthcare provider from performing gender transitioning surgery on or providing medication to a minor under 18 years of age and in connection therewith. Imposing liability on the healthcare provider that performed the procedure and any person who assisted until the minor is 48 years old or 10 years after their death. A healthcare provider is liable even if the minor and the parent consented to the procedure, allowing any person to advise the state's attorney general of a prohibited procedure and requiring the attorney general to file a lawsuit against the provider and anyone that assisted for up to 20 years after the prohibited procedure occurred.
Okay, I move that the title board set the title for proposed initiative number 2023-2024, number 175, as it appears on the freedom of resolutions.
All those in favor? Aye, that title has been set.
Thank you.
Thank you so much.